Why don't you go see your boyfriend?
Yeah, he's got a nice room. You won't have it long. He left a call for 7 a.m.
See if we can figure out something.
Listen to a file.
Hi guys. What a time to hit live. Frank is just digging his way to Australia in the litter box right behind the mic. I'm in the lounge, so the cam is a bit potato cam-ish. But here we are. Going live, emerges from the dead. We need to do like a proof of life check. He just went in there, moved the sand around, and came out. We need to do a proof of life check on Evie. Hey, Twitchy. Oh yeah, that crown thing. I'm not entirely sure what the game plan is there. Frankie. Okay, so I've got Kohberger pulled up and ready. And I was thinking we could watch something in the meantime, just knowing that I might have to suddenly cut it. Where is the thing I just had? Here. Okay. I don't know if there's a way at all. Unfortunately, I am just as lost on the whole setup as everybody else. Let's just go back a little bit. So this is a new attorney, by the way, in Detroit. Where can I sit? No, I want to sit on this side. Frank is going to shout. He doesn't like us talking to people on the laptops. This is a new attorney in 36th, and he seems to do very well. Sidebar, the mess behind them drives me insane.
One, shot. Personal. Curfew. No. Yes, tether. Curfew.
They've all disappeared now. And my other, I'm actually using Vaughn's spare laptop.
This one, Wiley. Personal.
Wow, what a place for me to start.
Yes, tether.
Frank, come here. Frank said he'll only come on camera for super chats.
All right.
Oh, that's cool. So you can basically, like, instead of having to only pay money for super chats and stickers, you can earn points. I actually prefer that because then people don't have to pay in this economy.
DDC, are you ready?
I can't find that stream on my phone now.
Yes, John, we're ready.
Thank you. Ma'am, what's your name?
You get points. for-
LaDonna Cherie Singleton, ma'am?
Yes, ma'am.
Thank you. Okay. Ma'am, I'm Magistrate Chate. Your case number is 250-5833001. Go ahead, Counsel Brico.
Judge, on behalf of Ms. Singleton, my client's been advised of constitutional rights. She waives before reading the complaint. She stands mute. She requests that this court enter a not guilty plea on her behalf.
Thank you. I'm going to enter a plea of not guilty. Court dates are July 14, 2025, probable cause conference, followed by preliminary examination, July 21st, 2025. Both matters are in front of Judge Taylor. The Singleton, you understand those court dates? Okay, all right. Ms. Singleton, let me give you some bond conditions, ma'am. 1, you're not to possess firearms or any other dangerous weapons. 2, ma'am, you're not to have contact with Alexis Smith. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Do you understand that, Ms. Singleton?
Yes.
Okay, all right. Counsel Vincent, go ahead, sir.
Magistrate, this is a reissue. You originally arraigned this individual, you yourself, January of this year. You ended up giving her a $50,000 personal. She ended up attending the examination, but the complaining witness failed to appear. The case was dismissed, and then it was refiled. Same charge. We don't have any objection to a personal bond at this time with that condition of the no contact.
Ms. Singleton, you're gonna get a $50,000 personal bond. Nobody has to pay any money for you to get out of jail, and I believe your attorney is not objecting. Is that correct, Counsel Brico?
Correct,
Okay, nobody
Magistrate.
move. I need to just
Thank
do
you.
something quick.
So, Ms. Singleton, nobody has to pay any money for you to get out of jail. Just please go to court when you have to. You understand that, ma'am?
Yeah.
Thank you, ma'am. That concludes your arraignment. You can step aside. Ma'am, what's your name?
Latoya
Latoya and Tree Sneed, ma'am?
Yes.
Thank you. Ms. Sneed, I'm Magistrate Chate. You hear criminal matter, case number 250-5824601. Counsel Brico, go ahead, sir.
Judge, on behalf of Ms. Sneed, my client's been advised of constitutional rights, waives before reading the complaint, stands mute, respectfully requests that this court enter a not guilty plea on her behalf as to all counts.
Thank you. I'm gonna enter a plea of not guilty. Court dates are July 10, 2025, probable cause conference, followed by preliminary examination, July 17, 2025. Both matters are in front of Judge Jefferson. Okay. All right, Ms. Sneed, let me give you some bond conditions. 1, you're not to have contact with Tamia Ali. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. The other thing, ma'am, is you're not to possess any firearms or anything else, any other objects that can be a dangerous weapon. Do you understand that, ma'am?
Yes, but I'm a carrier, so what would I do with my gun?
You can't carry it.
Okay,
You can't possess it.
okay.
Right now, while this case is pending, you're not to have any firearms or any other dangerous weapons. You understand that?
Okay. Yes.
Okay. Thank you. Counsel Vincent, go ahead, sir.
Thank you, Magistrate. Good afternoon, Steve Vincent, P71917. Magistrate, I hope you can appreciate this. In lieu of asking for a cash bond, we're not going to be objecting to a personal. We are going to be asking for a provision condition, no driving. Through the pendency of this case, it's alleged that this defendant ended up using her automobile as a weapon, trying to hit not one, but apparently 2 people in this incident. So because she doesn't have any priors or anything ongoing presently, I'm not going to object to a personal. In addition to the fact that it occurred in November of last year, we would respectfully be asking for that no condition of driving.
Council Rico, go ahead, sir.
Judge, on behalf of Ms. Need, I would ask you to adopt the recommendation of a personal bond. I would ask you to reconsider the recommendation of no driving, Judge. It's been quite some time since this incident occurred. My client has no prior criminal history, which means she doesn't have any pending stuff going on. My client hasn't had any altercations with her vehicle being used against other people in the past 7 months. My client is employed at a nursing home. She provided me valid hours in which she works. Presumably, she has to drive to that job. I would hate to put her whole life on hold in this instance. I understand this court needs to protect the public. I understand that the allegations involve a vehicle, but I also understand no prior criminal history and no incidences either with the specific complaining witness or any of the general public involving a vehicle on my client since this incident date of November of last year, Judge. So I would ask you to reconsider that and perhaps just the personal bond, strict no contact order with the person or place where this occurred, Judge. And of course, a condition of no driving without a valid license, I have no objection to that.
Council Vincent, response? Any response?
I think it's academic whether or not she has a license or doesn't have a license. I'm asking for a no driving provision because allegedly, and I thought I was actually being quite conservative in my approach, using her motor vehicle as a weapon, trying to hit somebody. But magistrate, you know how much I respect you. I'll leave it up to you, but we're going to stick to the ask for no driving.
Okay. Well, I am going to adopt the recommendation. Ms. Sneed, there is no driving, period. Not while this case is pending. Okay, but I will let you know that whoever your attorney is can approach Judge Jefferson as to not only your bond amount, but your bond conditions. And that one bond condition also includes no driving while the case is pending. Do you understand that, ma'am? Is that a yes or a no?
It's a yes. I just
Thank you, ma'am.
Sure.
All right. Well, there are other methods for you to get to work. I'll let you figure that out. But while this case is pending, up until you go in front of Judge Jefferson or Judge Jefferson hears any hearings on your bond conditions, right now, the no driving stands and you're going to get a $25,000 personal bond. Nobody has to pay any money for you to get out of jail.
Thank you.
Thank you. That concludes your arraignment, Ms. Sneed. Good luck. EDC, I'll see you at 2:30.
Yeah, what was that talking about? I'm sorry.
Oh, sure. July 10th and July 17th.
No, I'm out.
Oh, $25,000 personal bond.
Thank you.
Thank
Sorry.
you.
See everybody soon.
Bye, Mr.
Yep.
Vincent. Bye, Magistrate.
Oh,
Yes. Bye.
okay. Well, I wasn't expecting that. That's funny. So P. Diddy's verdict. New York Post says the headline, Diddy gets off. Yeah. That's the headline that they came up with. I am busy trying to get my description sorted. You just know some journalist is so proud of themselves. Like they were waiting the whole trial to say that. Let me quickly share my screen. That's what we are basically currently sitting at. So, yeah. Let's do that for a minute. I'm going to see if there is anyone who just went live. That is not going to be weird if we cut off in the middle. Let's watch Judge DeSanto a minute.
And in December, this court sentenced you to 90 days jail on your.
I'm sorry. How does that sound okay? Like, how you, there's no ways. How is someone supposed to understand what they're agreeing to when it sounds like in the 90s? So that one's not going to be it. Wow, this is really, haven't had to do, oop. No. Haven't had to do this on the fly in a long time. And I was trying to find, oh, this court is fun. Let's watch this for now.
Let's go to Raul Cardenas Cortez. And we've got 2 cases. What's the city's offer?
Thank you, Your Honor. We have in the 2024 cases, driving on suspended driver's license, no registration or failure to appear, case number 1, case number 2, no driver's license. So if he's willing to plead to the driver's license and no registration case, the city would move to dismiss the second no driver's license case, and I wouldn't be opposed to an opportunity to cure.
Okay, and so plead to 10619 dismiss?
Yes.
Okay, all right, Mr. Cardenas Cortez, are you there? Irma, are you going to amend that to a no driver's license, or you can keep it suspended?
Keep it suspended, Your Honor.
Okay. Mr. Cardenas Cortez, are you there?
Yes.
Okay, what is your plea to driving on a canceled, suspended, revoked driver's license?
Oh, guilty.
With Judge Susanto, though, that's the jail's audio. And it is so bad that there was one plea where I was in the chat on her actual channel, and eventually it got so upsetting and frustrating that somebody else in the chat phoned the court, and then the court went in and told the judge, like, yo, the audio is really bad. And the defense attorney didn't bring it to the judge's attention. The prosecutor clearly wasn't even listening. I wouldn't be surprised if that whole thing gets overturned. The guy was not able to hear, and the more he was like, sorry, Your Honor, I can't hear, the more annoyed she got. And so her volume would go up and up and up, and that was making it peak, and the audio was just getting worse. It was a disaster.
Okay, what's your plea to driving on suspended fictitious registration?
Guilty.
Okay, and you admit failing to appear on January 7th of this year?
Yes.
All right, how long have you been in jail?
4 days, I think.
I'm giving you time served on the FTA. On the pursuant to negotiations, the charge and the failure to appear on 10619, charges dismissed, and the warrant is quashed. Okay, this is what you're going to do. Are you going to get a driver's license?
Yes.
All right. So this is what you're going to do on the driver's license charge. It's going to be you're going to report upon release to the Reno Municipal Court when you get out of jail.
Okay.
And on the driver's license, I'm going to give you 45 days to get the driver's license.
Okay.
If you don't get the driver's license within that period of time, you're going to owe $195.
Okay.
If you get the driver's license within that time, it's going to be dismissed. As far as the registration, same thing. I'm giving you report upon release, the Reno Municipal Court. I'm giving you 45 days to take care of your registration. And If you don't get it done within 45 days, you're gonna owe $195.
Okay, I will do that.
Okay, that'll be the order. Thank you. Good luck. Make sure you report upon release.
Thank you.
Okay, Dick's son. Okay, we've got 3 cases. One is it? Okay.
Judge Department 3 is here too.
Well, I don't care. Department 3 can go sunbathe as far as go ahead. Go ahead, Department 3.
You can finish, Mr. Kim. Go ahead, or Mr. Sun, and then I'll do mine after that. He's already up there.
All right, Mr. Sun.
Yes.
We got 3 of 3. Paraphernalia, trespassing. We got, wait a second. Son of a, oh, there we go. Okay, hold on.
I like Judge Champagne as well. He's
Okay.
cool.
We've got the first one, 03645. What's the city's offer? We've got 2 that are violations, that are contempt.
He's
What's
interested in community court, Your Honor.
Okay, all right. So what, urban plead to the possession and go to community court?
Yes, Your Honor, thank you. And I would ask that he remain in custody because he's not compliant with court orders. He would remain in custody until next Wednesday. Thank you.
All right, Mr. Sun, are you there?
Yes.
Okay. What's your plea to the paraphernalia charge in 09188?
No contest.
Okay. Trespassing is going to be dismissed. You're going to be for sentencing. You're going to be referred over to community court, but it'll be a no bail hold since you don't show up for things. Okay, let's go to 05728. You admit failing to comply with the order of the court to do 16 hours of community service and go to community court?
Yeah, I recognize that.
Okay, do you admit failing to comply?
Yeah.
All right, how long you been in jail?
Just overnight.
Okay, I'm gonna give you time served on that. That'll clear that matter up. As far as because you'll be in jail, so, and on 03645, you admit failing to comply with the order of the court to go to community court and do 8 hours of community service.
Yeah, I think that.
All right, I'm gonna give you time served on that also, even though there's suspended time, I'm cutting you some slack. So those cases are cleared up. You're gonna be in jail until next Wednesday. They're gonna transport you down to community court. Do you understand?
Okay, yeah.
All right, that'll be the order. Thank you. Go ahead, Judge Champagne.
You're muted, Judge Champagne.
Thank you. How about Julian Avila? So, Mr. Nickel, this is a case that Mr. Edgerton has. It's set for a jury trial. There was something that was going to happen in Reno Justice Court. So we were just kind of doing a status hearing to see whether we were still on track for the jury trial. Do you have any information on that yet?
Fortunately, I don't. Mr. Edgerton's usually really good about, reaching out on things like this, but I have not heard from him. According to Mr. Avila, he's also set for a case in Second Judicial District Court where his attorney has filed a motion to dismiss. So I don't know that.
This time I have some information, Your Honor.
Oh, okay. Please.
So
thank you, Ms. Woodstander. Good morning.
Good morning.
What's the status here today?
What I know from Ms. Yao is that Mr. Avila had a trial in district court that ended up in a mistrial. So the DA's office is trying to make some decisions with regards to that case. Mr. Edgerton was supposed to have a date as to when the next hearing is set to provide to Mr. Nickel, so that way we can continue our case status hearing past that date. But if Mr. Nickel doesn't have the date, I don't know when it should be set for, but I do know that Iris Michelle is asking for the case status hearing to be continued.
Okay, and no indication from her as to changing the status of going forward on the jury trial at this point?
She did not mention that at all.
Maybe we continue to the next time Mr. Edgerton has videos, Your Honor.
Well, let's do this. Mr. Avila, good morning. I hate to talk about you like you're not even there. What we're trying to do is to figure out what we can do as far as scheduling your case for a jury trial here in Reno Muni Court. Do you understand that?
Yes.
And it's a big deal to do a jury trial. I don't want to go through all of the process if the case is not going to go. And a lot of this was dependent on what happened in district court. And I guess we're sort of in a holding pattern because of the mistrial.
Yeah, no, me and Mr. Edgerton decided to wait until my felony results before anything.
Okay. Is this person that's coming in, is this connected with Mr. Avila's case?
No, Your Honor, one of my victims in a different case.
All right. All right. So Mr. Avila, here's what I'd like to do. I want to talk with Mr. Edgerton and figure out exactly what's going on.
Thank you.
Are you in jail on the other matter? Is that keeping you in jail at this point still? Or are you on my case?
Just on your case and the felony that my attorney filed a motion to dismiss, so we're waiting on that.
Okay. Let's set this then for Monday. What I'll do is I'll check in on you on Monday morning on videos. I'm sorry, Jail. You're going to have him transported one more time. Deputy, I appreciate your help. I just want to see what's going on with this case. Okay.
Judge,
Yes.
can we do Tuesday? I'm not sure.
Monday. Yeah. Monday's always a pain. Yeah. Let's do Tuesday.
Okay, thank you.
Yeah. Okay. I'll see you Tuesday morning. Okay.
Thank you. You have a good day.
Thanks, Mr. Avila. All right, Ms. McComber, come on up here. McComber.
McCullum.
Good morning, Your Honor.
Good morning. We ready to get started?
Yes, sir.
Okay. You're released from custody. The conditions obviously are no alcohol, no marijuana. You will be tested. You must check in with the marshals and get set up on testing. Okay. All right. I'm not going to hear, I couldn't afford it. I'm working behind the scenes to try and make it as affordable as possible for you. You got to show up. You got to stay clean and sober. Okay.
Yes, Your Honor.
You got to be honest with me. The only reason you're in jail is because you lied to me yesterday. Okay. All right. Good luck. You are getting out at a dangerous time, right? You're getting out right before the 4th of July.
Yeah.
Be smart. I expect that you will check in with somebody by the end of the day today to be checked in with all of the pretrial check-ins. Okay. Come down to the courthouse today before 5 o'clock.
Okay. Yes,
all right.
sir.
Good luck.
Thank you.
All right. Thank you, everybody, for letting us jump in. Is there anything else I need on this, Val?
You want to do just the rest of the count?
Yes, we're good, Judge.
Okay, here we go.
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and pardon me, Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye. Here as well. Am I miss anybody? I'm sorry.
Ms. Allen is here as well.
Ms. Allen is here as well. Very well. Thank you. All right. We are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case. This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me, period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not continue to mount such campaigns or to send me information like this, because again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July with the questionnaire.
Sorry to pause, but this is going to bother me. Why did they have to rush it like this? Does anyone know? Why couldn't it just be like at the next court date? Or because also it didn't give the victims' families enough time to write statements. They were upset. The judge was caught by surprise. I don't see why it had to be rushed. Like, if the end result is jail forever or death row forever, why it had to be pushed into this like sudden, we got to go on Wednesday.
And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly. And so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom you, many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum, the defendant will plead guilty to all 5 counts in the indictment, burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes.
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that you so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Do you solemnly swear or affirm that the testimony you shall give in the matter not given before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Kohberger, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime to be enforced in the form of a civil judgment to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Is anyone other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case. Should you not plead guilty, did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogen, a human being, by stabbing Madison Mogen, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Goncalves, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogen, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice of forethought?
Yes.
Did you honor about that same date in Moscow, Idaho, kill and murder Kaylee Goncalves, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice of forethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing at his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m. on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Latah County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include a trial, video surveillance of a business on the Moscow-Pullman Highway just just across the state line from Moscow. It would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the 3rd floor, and with a knife, killed Madison Mogen and Kaylee Goncalves. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogen's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Kernodle was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the 3rd floor. It was on the 2nd floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were 2 other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom were to see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walinta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, this Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th of 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, in public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. You can try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence of 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Madison Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle. Thank you.
Thank you. All right, based on the state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogen, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Goncalves, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, pardon me, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. Court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than 1 full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in 1 day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties or the next week, the week of August 4 is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. Right. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. We'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor, thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing. So we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
We'd have no objection for the order to remain in place through
All right.
sentencing.
I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant. Were it would be revoked. The prior order allowing him to come in civilian clothes is revoked given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor, thank you.
I assume that the trial date will be vacated and those 4 jurors will be released.
The trial will be vacated and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned. All right, please.
I love how, as they say, all rise, Phoebe stands and then just lies back down. Okay, so I am surprised. My theory was always, so okay, let me rewind a bit. First of all, I generally have a good read on people. I obviously sometimes get it wrong, but normally I can pick up on things that my gut will be like, something's off. This one was a weird one for me because obviously there was the gag order, which meant that we only got one-sided information, and you cannot be objective if you only have one side of the story. That concerned me. I just quickly want to see why I'm potato cam. So that was something that concerned me, was we were only getting one side of the story and I couldn't make an objective decision without hearing the other side. The second thing was because of that, the initial information was a bit like, so in the early days, it was like, he was really interested in true crime and he was asking these questions on Reddit. And why would someone want to dive into the minds of serial killers? Why would he be asking these kinds of questions like, how did it affect you to be sentenced for murder? Or, just questions like that, that after being a journalist for, I think it's 10 plus years now, those didn't make sense to me. If you look at my search history and my research I've done on stories and all of that, it would be there because that's just a normal part of understanding crimes from like research perspectives. So that was the first thing that I was like, don't know about this. The second thing was, I just didn't think it was possible in the time frame they had. So it was something like 10 minutes. And that to me didn't add up. And I wondered, based on the fact that he'd been doing these questionnaires with killers and interviewing people, if somebody had framed him, if they had gone in and committed the crimes, if there was more than one person, the time didn't add up. The roommates not going in at all, and then calling 911 and saying, there's someone unconscious. I remember when the story first broke, there were pictures of blood coming out of the house because of the siding being wood. And I just couldn't reconcile being in that house with that happening and not noticing until midday. That didn't make sense to me. Then there were also things that I felt like people were bringing up as if they were big points that for a lot of us wouldn't be big points. Cleaning in the middle of the night. I have chronic insomnia. I can't do anything that uses my brain because I take a sleeping tablet. I will sometimes clean while I'm awake because what else can I do? There's nothing, like, it reaches a point where you're like, okay, I'm not sleeping. Other things like he said he went to watch the moon and people were like, that's so weird. My mom and I will send each other pictures of the moon and always have, and have gone for drives just to see the moon at a better angle. That didn't feel like a motive for murder. An alibi, like a strange alibi. It made sense to me. So I feel really, really blindsided. And when I saw the plea, I thought maybe there was some kind of broken telephone. Why would he take the plea when it wouldn't have been possible for him to do it? But what was also playing on my mind was I watched the interview Lawyer did with the crime scene expert. I wish I could remember his name. He was supposed to testify in the Reed trial. And he mentioned that he couldn't speak about the Kohberger case and that when his colleagues come forward, we'll understand why. And then I was like, oh, hold on. There's clearly something that the FBI found that is making them so confident. So that was kind of playing on my mind a bit like, maybe I'm wrong. Then the plea thing came out and I was like, maybe it's broken telephone. I mean, the news stories like he's taken the plea. He hadn't taken the plea yet. That was, yeah. So I feel really weird about that. And then I feel honestly like grossed out by when they were asking, did you kill, and then the victim's name, and he's like, yes. And then when they're like, how do you plead? And he's like, guilty. And he's listening to it sitting like this. You'd expect if it was something that he wasn't proud of, he'd be like head down in his hands. The prosecutor was crying. He wasn't crying. He wasn't even, he might be medicated. Some people, I don't cry very easily, but I will at least hang my head in shame, not be like proud of it. Yeah, shame. Vaughn's been up to date on this by proxy because I just couldn't figure it out at first, and then it bothered me for so long. I don't think he's covering for anyone. I think maybe either his parents pleaded with him to avoid the death penalty, or he decided he didn't want to die that way. The thing with the death penalty is he could appeal. He can't appeal this. He could appeal and maintain his innocence throughout. Or his lawyer go through that he was fighting a losing battle. Well, that's what lawyer and his dad were saying, that the lawyers did everything they could, and there is a chance that he was like, look, I did it. And they're like, this is your best chance. Unless he's heavily neurodivergent. He is. He has autism, and his lawyers did say that that is one of the reasons why he like comes off differently. But I found it really weird. Also, Vaughn's typing this from the room right next to that door. I feel like we need some kind of like palate cleanser, like something just to, I feel icky. I'm going to see if there's something that is less, come Frankie, less intense to watch for a little bit while I, Frankie, plug things in and whatnot. Just give me a sec, because multitasking is not it. Vicky Mac. Frankie. Frank wants to speak but not be on camera. I've tried to get them to just chill in front of the camera. Judge Simpson took his videos down already. Of course. Da, 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 da. Oh, P.S. I am applying to study law. It has taken, I don't know how many years since I left school, but I have finally decided it is time. Let's see. You can't hear that, can you?
As laid out in this worksheet, having committed new charges on
fully engaged in being her father and
Mr.
I'm doing a great job as a father. Certainly that could be punishment if he doesn't correct his ways and become a solid citizen. So that's what I'm asking. Close the probation, give him time for the time that he served here, or give him 45 days and let him move on and let Wayne County take care of it.
Right. Interesting. Mr. Anderson, anything you wanted to say before the court addresses the sentence?
This is funny because, like, buddy, in my last conversation with my GP, I was like, listen, the 70 milligrams of Vyvanse, like I could go up one. And she's like, You don't get a higher dose. That is the highest you can get. So I guess you're just really ADHD. And I was like, wow, thanks. That's something I've always wanted to hear. Okay, let's rather go to this guy.
Person at the jail, what is your name?
Jason Whitney.
This is case number 241172 SM, the people of the state of Michigan versus Jason Robert Whitney. Mr. Whitney, what is a good mailing address for you?
12761 Meadow Lane or Meadow 6777.
That's me trying to shield his personal details. It didn't work very well.
I have a probation violation that alleges new criminal behavior, and specifically it alleges that a domestic violence third was reported by Livingston County on or about April 9th, 2025. If you are found guilty of that violation, you could be sentenced to what you could have been sentenced to under your original charge of stalking, which is a 1-year misdemeanor. And this is not your first violation. I've got two, it looks like 2 prior non-technical violations. You also had the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, one would be appointed to you at public expense. But you may be required to repay a portion of that expense. Today, do you wish to have the court appoint an attorney? Do you want to represent yourself or hire your own attorney?
At this time, use the public defense until I see if I got an attorney.
All right, the court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea, and we'll set the matter for a contested hearing. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at a future court appointment, the seriousness of the offense charged, and the threat that you pose to the public. Mr. Roberts, any comment regarding bond?
Yes, Your Honor, a couple things to note. Mr. Whitney is out on a cash bond out of Livingston County. He posted $2,500 for that. He also turned himself in for this probation violation. He's been showing up to court as required for both Livingston County and previous matters through this county. And so we don't believe Mr. Whitney is a flight risk, despite the fact that he does live some distance away. We also believe any danger to the community could be mitigated by both the cash bond he's posted elsewhere and any non-monetary bond conditions the court would impose.
Thank you. Prosecutor's office.
Thank you, Your Honor. As the court stated and is aware, this is not the defendant's first probation violation. On top of that, our office does have reason to believe that the defendant has had contact with the original victim from this case, or attempted contact. We are waiting for reports on that. In the meantime, we would ask for a remand in public hearing. Thank you.
The court will remand the defendant to the custody of the Wexford County Jail until we have the hearing. Next arraignment.
Okay.
Your Honor, does it matter that I am doing GD classes also?
Mr. Whitney, I've remanded you to the jail.
Okay, thank you.
I need your human to leave next week.
Person at the jail, what is your name?
Michael Kushmiter.
This is the case of the people of the state of Michigan versus Michael Dale Kushmiter, case number 252885FY. We're here for an arraignment. Mr. King, do you appear on behalf of the defendant?
I do, Your Honor. Stephen King on behalf of Michael Kushmiter, firm of King and King.
Okay, thank you.
Judge, if it helps, we would waive the reading of the formal complaint at this time and ask the court that my client stand moot and a not guilty plea be entered on his behalf.
All right, Mr. Koschmider, before we do that, I want to go through your rights with you. You do have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and you also have the right to stop answering questions. You also have the right to be represented by an attorney at all phases throughout this process, and if you cannot afford one would be appointed to represent you, but you might be required to repay a portion of that expense. And Mr. King indicates that he's here representing you. Are you aware of that?
Yes,
And did you understand those rights that I just went through?
yes.
All right. Based on Mr. King's representation, we will go ahead and enter a not guilty plea. We'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution is required to prove two things: one, probable cause that these crimes had occurred, and two, probable cause that you were the person who had committed that offense. If they are not able to do that, the case would be dismissed. If they are able to do that, you'd be bound over to stand trial in circuit court. Do you understand that?
Will you please repeat that again?
Sure. So we will set this for what's called a preliminary examination. And that's just a hearing that's held here in the court within 21 days. And at that hearing, the prosecution is going to be required to prove two things. One is probable cause that these crimes that you're charged with happened. And the other is that you were the person who committed the offenses. Do you understand that so far?
Your Honor, he has a very limited ability and capacity. We're currently working, he's on probation. He is working not only with his probation officer religiously, he is also seeing a counselor regularly, and his mother and stepfather here were involved with him on a daily basis.
Okay.
And I'll get into some more of the things for the bond considerations.
All right. Mr. Koschmider, you also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the threat that you pose to the public, and the seriousness of the offense charged. Counsel, I show in 14, there was an attempted CSC4, and in 24, a CSC4 that he's currently on probation for now. I also see, I've received the praxis. Mr. King, I don't know if you've received that or not. It's a new thing Community Corrections does, it gives us a risk level assessment. I'll give you, take a look at that. I say it's new, I guess I've been doing it for about a year or so. Any comment regarding bond, Mr. King?
Yes, Your Honor. First of all, I think it's important for the court to know that since my client has been put on probation, his stepfather and mother who are here in the courtroom have retained us as counsel. And there are several issues relating to that, but the most important thing for the court in making its determination is Mr. Koschmider has appeared every time he's been asked to appear with his probation officer, Lindsay Simmons. He has followed her direction. He is a very limited mental capacity judge, and we're in the process of getting more reports in regard to that, as the court can see has a hard time understanding it, but he will follow direction. He has made every court hearing as required. He remains in constant contact with my office, with Jeff Mankiewicz, who he's working with, to answer any confusion on anything that is related to that. The concern, as I understood it, that led to the probation violation, which was dismissed, I believe, today in this current issue, is that he not have a phone that has any internet access. We were able to provide, I believe, the prosecutor's office, but also the probation officer, with to be able to communicate with his mother. He now has a simple flip phone that has no internet access. Under the other consideration, he needs regular contact and access to his judge, and I do not believe he is a threat to anyone in this community. There has not been one incident that has occurred since he's been on probation that has anyway been an indication that there was a threat to anybody. As I said, full cooperation with appearances, full cooperation with meeting with Lindsay Simmons and complying with everything. Melissa Cutterback is his counselor and wants to make sure that he can continue his regular contact with her. We would like him available for further testing as to his ability to comprehend the nature of these charges and to look into the intent of what the charges are. I would say to the court that while we're working with the prosecution, we do not have any of the evidence that was used for the probable cause for the warrant to evaluate whether it's even legitimate or not. Judge, we can tell you he is not a threat. He is in contact with our office. He works with his mom and stepdad on a daily basis. It would absolutely be a crime to keep a person of this limited ability in jail at this time for anything other than personal recognizance bond. last thing I would note, Judge, on this issue, Jeff Banquets in my office had worked with Mr. Carnes for my client to turn himself in voluntarily. And something got glitched, so he was arrested before we were bringing him in to do it. So everything has been done to assure the court that there are no safety concerns. We would ask for a personal recognizance.
Thank you. Prosecutor's office.
Thank you, Your Honor. I won't go into too much detail, but I know the court is aware of these charges and what they entail, which is extremely concerning in and of itself to the people. On top of that, the defendant does have prior convictions for charges involving criminal sexual conduct as early as last year. I do think that that poses a threat to public safety. Until we know more about maybe the defendant's mental competency, I do think a $100,000 bond would be appropriate in this case, Your Honor. Thank you.
One more comment, Your Honor. The prior charges involved two people that had moved into his home. And in my opinion, put him in a compromising situation. Again, those charges at the moment stand. We are looking at legal possibilities for challenging the current conviction. And my point is, it's because of the mental capacity of my client, Judge. He is not a violent offender. He is not someone that you have to worry about. And not only do we have probation supervision, counselor supervision, attorney supervision, and supervision of parents.
Did you say the probation violation's been dismissed?
I think we've agreed.
No, it's not. It's been adjourned to track with this case since it's all the same facts. So we wait for 14 days, then it's been adjourned.
Okay, I was under the understanding it was being sued. Doesn't matter. Everything else still applies, Judge.
Well, I don't know, Mr. Carnes.
I may make one, and I would ask for conditions of no access to the internet and no unsupervised contact with children under the age of 16. Thank you.
I don't necessarily remember the facts of his case of the 24 case. I was the prosecutor at the time, so I do remember Mr. Koschmider, and I am familiar with his limited capacity. If I recall correctly, he was employed at that time. Is he still employed?
Michael, are you still employed?
Work with Scott Faber.
That's his stepdad,
Okay.
Judge,
All right.
who is here today also.
Does he live with mom and stepdad?
He does not. They're within about 5 minutes of him and lives right behind the courthouse here.
As a condition of bond, defendant is to appear as ordered, keep his contact information, not leave the state without permission, and to commit no new crimes. I'm going to order that he not have no unsupervised contact with anybody under the age of 16, that he not act in any threatening, harassing, intimidating behavior, to be placed on house arrest with GPS tether, terms to be set by community corrections. I'm also going to order that he not have access to the internet. You said he is in counseling right now?
Yes, that is correct.
I'm also going to order that he continue counseling. I will release the defendant on a person recognizance bond. Anything else in a in a pretrial release order, Mr. King?
Your Honor, I don't think so. If I heard you correctly, his probation officer would be allowed to let him go to work as part of the conditions. It would be her discretion.
Yeah, so house arrest, that's usually that is one of the conditions that he is able to go to work. He'll just need to pre-schedule and have it prearranged.
Right. Thank you, Your Honor.
Anything else from the prosecutor's office?
No, Your Honor, thank you.
All right, thank you.
Thank you very much, Your Honor.
Thank you. Oh, yeah, Mr. King, we don't have an appearance yet from your office, so if you could get that.
I will
filed.
absolutely get that in this afternoon.
Thank you.
Thank you.
Thank you, Jail.
Thank you, Your Honor. Have a good day.
Melissa Gates.
I think she went to the bathroom. She was here.
Okay, this is the people of the state of Michigan versus Melissa Ann Gates. Is it Gates or Gouts?
Gouts.
Gouts, sorry about that. Make a note of that. This is case number 252866 SM. We're here for an arraignment. Ma'am, what's a good mailing address for you?
711 Colfax.
Do you have a good telephone number?
231-942-3803.
And how about an email address?
My last name and my first name at Gmail.
Did you have the opportunity to meet with somebody from the defender's office today?
I did.
I have a complaint that alleges that between the dates of May 20th of 2022 and May 6th, 2025, in the city of Cadillac of Wexford County, it is alleged that you did commit the offense of stalking of a Nicholas Marinelli. That is a 1-year misdemeanor and or a fine of $1,000 up to 5 years probation. Do you understand those charges and the potential penalties?
I do.
Did you read and sign this advice of rights form, talk about your rights to an attorney in trial? Did you understand those rights? You do have the right to be represented by an attorney at all phases throughout this process, and if you cannot afford one, one will be appointed to represent you, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request one.
And what is your current source of income?
I have a home cleaning business.
Are you self-employed?
Yes.
All right, the court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea on your behalf, and will set the matter for a pretrial. That's where your attorney and the prosecutor on the case will have a meeting and see if there's a way to resolve the case short of going to trial.
Okay.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. And it looks like you posted a $500 bond.
I did.
All right. Historically, counsel, I show in 09, 2 aggravated assaults, in 10, 2 assault and batteries, in 21, a possession of meth, 21, disturbing the peace, 21, open and tox, and a 22, possession of meth. Any comments regarding bond, Mr. Roberts?
Yes, Your Honor. Just the full flight risk, excuse me. She does live locally and she lived here her entire life. And as the court may recall, she has been at this date and then was here previous for other matters. So we don't believe she's a flight risk. Additionally, we believe any safety of the community can be mitigated by both the bond she posted yesterday and the non-monetary bond conditions that are already imposed. We would just ask the bond be continued forever.
Thank you. Prosecutor's office?
Thank you, Your Honor. Facts of this case involve the defendant's father of her children as well as his wife, and repeated contact with them. We would also ask for bond to continue. We would just ask for no contact order with both Nicholas and Laura.
So we're dealing with a over 3-year time period. When was this received in your office? You know?
This report was received on June 18th.
Okay. All right, the court will go ahead and continue the bond as previously posted. Ma'am, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not have any contact with Nicholas or Laura Marinelli. No contact means no contact of any kind, not by phone, text, Facebook, anybody on your behalf. If you are found in violation of your bond, you could be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that? All right, I'll need you to go back out to the front window where you checked in, get a copy of your next court date. You'll also have some paperwork for you to fill out for the defender's office as well. Okay?
Thank you.
Thank you.
Okay. I don't have an outro video, so this is what I'm going for. I'm going to say goodbye now because I need to finish writing. What is the story I was writing earlier? It's actually a story from this year. I'm not on my laptop. I want to say Mary. Gone blank on her name. Was very in depth, and I want to finish it before I wrap up my day.
All right, court calls the people of the state of Michigan versus Jordan McDonald.
He just popped back up. Thank you, guys. I will see you soon. I probably won't put a video out tomorrow because of the live today. But I'm trying to do at least Tuesdays and Thursdays weekly if it's a normal video. Otherwise, I'm trying to slot in some lives. But it's not easy. Not with a full-time job and posting YouTube videos. I will see you guys soon. Thank you so much for hanging out. And yeah, make sure your notifications are on, because apparently only 2% of people get the notification. Apparently, allegedly. Bye.